I know you guys have a lot to cover, no doubt. Um, so I'd like to welcome everyone to the California Workplace Update that is sponsored by Jackson Lewis. Navigating the ever-evolving landscape of California's employment laws is challenging, to say the least. So our speakers today are here to help us be informed and stay compliant. And today they're going to be talking to us about the latest developments in case law, legislation, administrative regulations in employment law for the Golden State. Our speakers today are Peter Moretz and Claudia Murga, both of Jackson Lewis. And Peter is a principal at Jackson Lewis and serves as the litigation manager for the San Diego office. Peter brings 3 decades of experience as a trial lawyer and has a successful track record of defending wage and hour disputes, PAGA claims, and cases involving sexual harassment, discrimination, and disability compliance. Outside the courtroom, Peter also provides advice and counsel to employers in the hospitality, transportation, logistics, and life sciences industries. In his spare time, he likes to enjoy world travel, playing guitar, and cooking. A little about Peter. Our other speaker is Claudia Murga, who is an associate at Jackson Lewis and also based out of the San Diego office. Claudia's experience includes advising employers on implementing programs and processes designed to mitigate the risk and costs of employment litigation. She's also experienced in conducting investigations on a wide range of claims, including those relating to workplace misconduct, discrimination, harassment, hostile work environment, and retaliation. Claudia is a San Diego native, and outside of work, she enjoys giving back to the community, spending time with family and friends, and taking her energetic schnauzer to the dog park. With that, on behalf of ACC, I'd like to thank Jackson Lewis for sponsoring this today and thank our speakers for being here. And with that, I will hand it over to them.
Awesome. Thank you so much, Sierra. Thank you, everybody. It's nice to be in the space with you, and it's a privilege to speak with you today. For our legal updates or annual reminders, I guess we're calling them. A lot of stuff is going into place starting January 1st of next year and some July of next year. And so we're going to touch on them. We have a lot of material to cover, and so we're going to hustle through it. If you have questions, we'll try to answer them as we go. If not, we'll get to them at the end. If not, we may need to follow up with you. But again, thank you for the privilege of being here. I'm going to kick things off with discussion of the annual minimum wage increase. Starting January 1st, the state minimum wage is going to go up to $16.90 an hour. And that was, we knew that was in the books for a little while. Keep in mind that this also changes the minimum salary that you pay your exempt employees. So, and most of you are dealing probably with administrative or executive exempt. The minimum salary for those folks is 2 times minimum wage, a monthly salary of 2 times minimum wage. Keep in mind that this is done on figured on a monthly basis. So it'd be $5,858.67 a month minimum. And most important to point out is you can't sort of retroactively meet that minimum with bonuses or any kind of incentive pay, or the employee needs to know going in that they're going to be making at least $5,858.67 a month. If you have that, and then assuming the employee is working and performing the duties that support the exemption. In other words, more than half their time is spent exercising discretion, judgment, and then for executives exempt employees, directing the work of at least 2 other employees. They don't have to necessarily be their direct supervisor, but they have to direct the work of at least 2 other employees. Then the exemption.
Peter, sorry to interrupt you. Could you speak up, or maybe we're all hearing it's very faint?
Oh, I'm sorry. Let's see.
We're not able to hear you very loudly.
My microphone is turned up.
Maybe just
Go a
up
little
your voice
closer.
a little
How
bit.
about that? Sorry, I got to see more of my face. Um, and so I'll speak up. And then and then if we could just jump to the next slide, Claudia. Claudia is controlling the slides. Um, the keep in mind that what prevails is not necessarily the statewide minimum wage. But if you are in a locality that has its own minimum wage, as many do, and we show several of them here, including San Diego, the higher state minimum wage, I'm sorry, the higher local minimum wage is what you pay. So without regard to the statewide minimum wage being $16.90 starting January 1st, San Diego, for example, will go to $17.75 an hour. And they're also industry specific, and we don't actually list these here, but they're industry specific minimum wages. We see that with there are hotel ordinances that have been on the books for a couple of years in Los Angeles, Santa Monica, West Hollywood, and then the airport hospitality enhancement zone around LAX have had higher minimum wages. San Diego is also getting its own hotel, amusement park, and event center minimum wage. That's going to be July 1st of 2026. So hotels with at least 150 guest rooms, the minimum wage is going to go to $19 an hour. Likewise, amusement parks that have at least 75 contiguous acres, the minimum wage is going to $19 an hour. And event centers such as Petco Park, Pachango Arena, the Convention Center, the Civic Theater, they'll go to $21.06 an hour. Again, if you're in that, if your business is in that sphere, then you're guided by that minimum wage, a higher minimum wage, even if you're without regard to the statewide minimum wage, without regard to even the city minimum wage. And lastly, on minimum wages, I talked a bit about the impact on your salary, the minimum salary for exempt employees, the local minimum wages, whether it's a citywide minimum wage, an industry specific minimum wage, those don't actually impact what the minimum salary has to be. The minimum salary just goes by the state minimum wage. Now, Claudia.
Okay, so we're moving, victims protections and leave. Assembly Bill 2499 became effective January 1st, 2025. And so prior to AB 2499, California law provided protections to employees from discrimination or retaliation for taking time off for things such as jury duty, court appearances, or if employees were victims of crime or abuse. So under 2499, excuse me, these protections do remain in place, but now we're broadening the definition of victims. So victims will include a victim of a qualifying act of violence. So what that includes is, for example, domestic violence, sexual assault, stalking, and then there's also an act, conduct, or pattern of conduct that includes, this is a little lengthy, so bear with me. An individual causes bodily injury or death to another. An individual exhibits, draws, brandishes, or uses a firearm or other dangerous weapon with respect to another. And an individual uses or makes a reasonably perceived or actual threat of use of force against another to cause physical injury or death. So what's important to note here is that these qualifying acts of violence, so regardless of whether anyone is arrested for, prosecuted for, or convicted of committing a crime, that's separate and apart. So just, be mindful of that. And also too, I want to point out, it's on the screen, but this has moved under the California's CRD, Civil Rights Department. And then there are mandatory notices. So employers are required to provide written notice of employees' rights established under this bill to new hires annually and upon request. So also too, if an employer becomes aware that an employee or the employee's family member is a victim, you do have an obligation to provide this written notice, and it can be downloaded from the CRD's website.
Yeah, I've changed my microphone. Are people hearing me better?
It's still about the same. I don't, Claudia, I can hear you very well, but Peter, it's still not.
You know what might help, Peter, is your laptop closed?
It is. I took it off the laptop microphone.
Because when you open the laptop, because I've done that before, and it just like picks up it picks it up better.
How about that?
Yeah, I think that will help a little bit.
Mm. Is that better? Nope.
Not so far, but
How about now?
oh,
Oh,
that's better. There
that's
we go.
good. Yeah.
Claudia saves the day. All right. Sorry about that, everybody. Um, let's talk about harassment prevention, training compliance. Actually, the changes were put into effect 2025. Make sure everybody knows for years now, we've had to train people, supervisors, give 2 hours of training every 2 years and within 6 months of their onboarding. Um, make sure that your now hourly non-supervisory employees are getting at least 1 hour of harassment training. And in both cases, that must include some discussion of bullying and in the workplace. Bullying still not against the law per se, but a bad idea. One thing we do also recommend, 2 points I want to make. One, first thing is we recommend that you actually, rather than having, if you're going to, particularly if you're going to do live training, you can do, and the training can be online, and there are obviously a number of online portals for that. But if you do live training and consider the value of that so that it's tailored to your business, many of my clients are hospitality clients. They have their own harassment vulnerabilities, not just from other employees, but from guests, people in guest rooms. So we can speak to that directly. But we add on an extra half hour and talk about discrimination. And discrimination in the workplace is no less a concern than sexual harassment. For whatever reason, the legislature hasn't saw fit to require that we train on it, but that is something to think about. Another point I want to raise to y'all is coming next year, you will have to produce the sort of the scope of what is part of an employee's file. You all get these requests from plaintiffs' attorneys asking to see their clients' files, produce personnel file, produce payroll records. The definition of personnel file is expanding to include educational and training material, and not just the certificate that they took the training, but some information about the trainer and the curriculum. So keep all that in mind as you administer your training programs. Now let's jump into case updates, and Claudia, you're going to talk about meal period waivers.
Yes, so the California Court of Appeal in Bradsbury versus Vicker Operating Inc. held that prospective written meal period waivers for shifts of 6 hours or less are lawful. Most importantly, they just need to be voluntary, revocable at any time, and not coercive. And this is deemed consistent with the labor code.
So,
And oh,
no, go ahead.
sorry. Oh, and then practical implications for employers. So this decision does provide a clear legal basis to use blanket prospective waivers for short shifts. Employers should just, really make sure that the waivers are revocable, they're not coercive, and properly documented. And best practice is to give employees a meaningful choice and remind them that they can revoke at any time. So just keep that in mind.
Yeah, so I think where I have a little bit of concern in this arena is when we're going through the onboarding process. We have make sure that the people who are doing that for you know that this is not something that people have to sign. It's going to be, I get concerned when the meal period waiver is sort of in there, was stacked in with the employment agreement, the all different acknowledgments of receiving policies, the arbitration agreement, and it just gets lost, and people are going to say, you just have to sign that, just sign that, just sign that. There must be meaningful discussion and some record of it, and whether that's a memo that sort of summarizes, here's what you have, this is optional, and it's revocable, to avoid the argument that I didn't know what I was doing and I was just told to sign everything. There was a decision from the California Court of Appeal on paid sick leave rates. So when you're calculating paid sick leave for hourly employees, it's a look back on based on their regular rate of pay, which is not just their base hourly rate, but it includes other non-discretionary premium pay, such as objective bonuses, performance bonuses. Again, I keep looking to the hospitality space. Front desk people will get they get incentives when they upsell you into a nicer suite, and they get you to pay more for your room. They get a piece of that. That all goes into the regular rate of pay for overtime calculation, and it goes into your sick pay calculation. For outside salespeople, the argument was in this Herdman case that they're getting paid a base salary, but they're also getting commissions. And the question was, do the commissions go into their sick pay calculation? And the court said that it does not. That is just if how you calculate paid time off for your salaried employees is to just include the base salary, which I recommend, then that's what their sick pay rate is. It will not. It does not. It doesn't need to include their commissions. And just a quick little touch on what exactly is an outside salesperson. It is in California, it's somewhat technical. Really, they have to spend more than 50% of their time away from the office selling your goods or services or obtaining orders for products for use of facilities. So 51% of their time has to be on the road, and obviously on the road selling. For people that work out of their home is considered their office. So even if your offices, your formal offices, are just down the road from this person's home, if they're at home and that's where they regularly work, that is their office. And frankly, the court didn't speak to this directly, but if half their time's at home, half their time's in the main office, I would consider all that office time. They really need to be out on the road calling on customers for that to be considered their outside time. Let's move to arbitration fees. So since 2019, the law had been in California, and this was as part of the California Arbitration Act, and specifically CCP 1281.98. It was a harsh, strict rule. And that rule was if you miss, you have 30 days from the due date to pay your arbitration fees. And whether the arbitration was commenced voluntarily by the employee, agreement with you and the employee, or you move to compel arbitration. Once AAA or JAMS or Signature or ADR, any of them send their invoice, the invoice will almost certainly say due upon receipt. You have 30 days to pay it. The rule had been since 2019, the 2019 amendment to the California Arbitration Act was if you blow that 30 days, even by a day, you're deemed to have waived arbitration. It was strict, and it was unforgivable. In August of this year, the California Supreme Court decided the Hohenschelt case, Hohenschelt versus Superior Court. And it really took a look at the legislative history of this 1281.98. And it was clear to the court that the driver behind that amendment was not people missing it by a day, but it was employers and other businesses were they'd get a case into arbitration and then they'd sit on it, and they'd sit on an invoice for months or even years. And the court talked about a situation with Chipotle where they moved a representative or a collective action rather into arbitration and then didn't do anything with it for 2 years. And the arbitration couldn't move forward because their bills, their fees were unpaid, and folks couldn't go back into Superior Court because they were in arbitration. And what Hohenschelt said was, it didn't say necessarily that you missed by a day, you haven't waived it. But it said if it's mistake, inadvertence, excusable neglect, and simple negligence that you missed a deadline, that's not what 1281.98 is about. If it is if the failure to pay is willful, if it's grossly negligent, if it's really what it's focused on is if it's fraudulent or strategic, they talk about it being strategic. That's where you'll be deemed to have waived your right to arbitration. Now, that doesn't mean you can just be cavalier about it. Like I said, the case didn't say that necessarily missing by a day or two is fine. It just said it's not an automatic waiver. So still, the smart move is to calendar it correctly and get it paid within 30 days. But if you happen to miss it by a day or two, the likelihood is you'll be okay. Let's get into some legislative updates and starting in the labor space.
Okay, so Assembly Bill 1340. On October 3rd, 2025, Governor Newsom signed Assembly Bill AB 1340, which establishes the Transportation Network Company Drivers Labor Relations Act. That's a mouthful. This act will take effect January 1st, 2026. And the purpose of this is to grant certain gig drivers the rights to form and join driver organizations, bargain collectively, engage in concerted activities for mutual aid. And this is administered by the Public Employment Relations Board, known as PERB, which oversees elections and determines unfair practices. So these platforms are what we commonly known as, for example, Uber, Lyft, DoorDash, Instacart, Amazon Flex. And so what will happen is that starting January 1st, 2026, every 3 months thereafter, the transportation network companies, TNCs, they must submit to PERB a list of information for drivers who have completed at least 20 rides in California within the preceding 6 months. So this would include their most recent email address, driver's license number, phone number, mailing and local residence addresses, platform joining date, and number of rides completed. So then PERB will, within 2 weeks, compile a list of drivers who have completed the median number of drives or more and deem those drivers as active TNC drivers.
So speaking of PERB, its primary function is to represent, essentially it's the NLRB for public employees in state. And there is Assembly Bill 288. If it does go through, it's been signed, but the NLRB is seeking to block it, at least the modification that I'm about to talk about. But if private employees, under certain circumstances, can't have their rights, whether it's their rights to organize or to have unlawful unfair labor practice charges, ULPs, processed through the NLRB. If they're just dying there, then PERB would have jurisdiction, and PERB could essentially take over. This is significant, and for the last year, the NLRB has been has not had a quorum, I think that's going to change. That's expected to change this week or next week with two recent nominations. But at the start of the year, the one of the board members um, was terminated, and the NLRB was without a quorum. So the things have just languished. Any claims, appeals before the NLRB have just sat. But that's expected to open up. And this is not something that's new. I handled a case, gosh, I think it was starting in 2011. And it sat because there was no quorum. And this had to do the recess appointments. That case sat until I believe 2017 or 2018. And if these changes to PERB are ultimately put into place, then things like that won't happen for California employees. And then Claudia, do you want to talk about employee agreements?
Yes, so we have Assembly Bill 692, prohibition on debt agreements. So Governor Newsom signed AB 692, which adds section 16608 to the Business and Professions Code and section 926 to the Labor Code. This applies to all employees in California, so it essentially makes it unlawful to include in any employment contract or require a worker to execute as a condition of their employment a contract that includes terms that require a worker to pay an employer, training provider, or debt collector for a debt if the worker's employment or work relationship with a specific employer terminates. And there are some allowances for contracts for repayment under the law. We have a few exceptions here. For example, a contract entered under a loan repayment program or loan forgiveness program by a federal, state, or local government agency, a contract related to repayment of the cost of tuition for a transferable credential if certain requirements are met, a contract related to enrollment in an apprenticeship program approved by the Division of Apprenticeship Standards, a contract for the receipt of a discretionary or unearned monetary payment at the outset of employment. This would include a financial bonus not tied to specific job performance, provided that certain terms are met. For example, the terms of repayment are separate from the employment contract. The employee is notified of their right to consult an attorney about the agreement and provided not less than 5 business days to consult an attorney. Repayment is prorated based on the remaining term of any retention period, which must not be more than 2 years without interest or accrual. And the worker may defer receipt of the payment to the end of the retention period without repayment obligations. And one last point here, separation is either at the employee's sole discretion or due to employee misconduct. And then lastly, any contracts related to lease, financing, or purchase of residential property. And then we also hear, well, tuition reimbursement, which was briefly touched on. So if it is a contract for tuition reimbursement, certain criteria must be met, which is laid out here. It has to be separate from the employment contract. It can't make obtaining the transferable credential a condition of employment. It has to specify a repayment amount not exceeding the cost of the credential to the employer. It has to provide for prorated repayment without acceleration, and then it can't require repayment if the employee is terminated unless it is for misconduct. And then, oh,
I was going to say that,
yeah,
that's just another reason why any for-cause terminations need to be very well documented, because that will be challenged.
yes. And so we have here discretionary monetary payments. So Business and Professions Code 16608 does not apply to contracts involving the receipt of discretionary or unearned monetary payments. So what this means, practical implications for employers is that you must very carefully distinguish between earned compensation, which is protected, versus discretionary unearned payments, which are potentially subject to repayment conditions. Employers should caution and in draft agreements clearly labeling payments as discretionary or unearned if they want repayment provisions to survive under Section 16608. And now we will be transitioning over to wage and hour.
So thank you, Claudia. So SB 464 made some changes to the pay data reporting requirements. That's something that was put in 2 years ago, where you have to submit, if you have 100 more employees, you have to submit annual pay data reports to the Civil Rights Department. And they want employee counts by race, ethnicity, and sex across 10 job categories. It's going to align with your EEO1 forms. You have to report on employee earnings, the mean and the median hourly rates by race, ethnicity, and sex. And then to this point, the penalties of $100 per employee or $200 for repeat offenders, $200 per employee for repeat offenders, was at the court's discretion. And it includes not just your direct employees, but also those through labor contractors like staffing companies. The changes are coming are the not insignificant, but the penalties are not mandatory. And your demographic data has to be stored separate from your personnel records. So just a little bit, sort of housekeeping that you have to keep in mind. Your reporting deadline is May 12. I believe it's May 12 every year, but it's definitely May 12 this year. And then in 2027, the 10 job categories is expanding to 23. That's based on the standard occupational classification system. That is, those are available online. But start your planning now. Coordinate with your vendors to ensure that all the data is complete in time for the May 12 deadline. Evaluate roles to know which go into which category, into which of the 23 categories. If you look, and we can provide the link, you look at those categories, the description is fairly robust. So it shouldn't be that difficult, but it is going to take some time. And to the extent that the assignment into the different categories impacts your EO1 reporting or impacts the race characteristics, be prepared to take a look at that and possibly realign things.
Okay, so we have some new guidance on what constitutes a cause of action for violations of the California Equal Pay Act. So a cause of action under SB 642 arises when an employer pays an employee wages, benefits, or other compensation less than those paid to employees of the opposite sex or another protected category. So this is including non-binary employees for substantially similar work, and the disparity cannot be justified by any legitimate, job-related factors such as seniority, merit, or production-based systems. And we have a few amended definitions. So, for example, pay scale will change to a good faith estimate of the salary or hourly wage range the employer reasonably expects to pay for the position upon hire. This definition relates to job posting requirements for pay transparency. We'll also see a amended definition to sex to align with the Fair Employment and Housing Act, FEHA. Wages and wage rates will includes all form of pay, salary, overtime, bonuses, stocks, options, profit sharing, insurance, vacation, holiday pay, allowances, travel reimbursement, and benefits. And this is only for equal pay requirements. And SB 648 was signed into law in July 2025. This strengthens protections against tip theft. So effective January 1st, 2026, SB 648 authorizes the Labor Commissioner to investigate, issue citations, and even file civil actions when employers unlawfully take or withhold gratuities. It also creates a private right of action, allowing employees themselves to sue for violations of California's gratuity laws under Labor Code Sections 351.
And this also, it authorizes the Labor Commissioner to investigate and issue citations for violations of the tip laws of Labor Code 351. Tips are a delicate issue. Tips are, and for those of you who have tipped employees, they're the sole property of the employees for whom they're given. And there are certain circumstances where where an hourly supervisor may share in the tips, but the default should be if anyone directs the work of somebody else, sets their schedule, and directs their work on a day-to-day basis, even if they're hourly, they're not to share in the tips. What the notable, really landmark exception that we saw was in the Chow versus Starbucks case, where it considered a patron at Starbucks, they're dropping money in the jar or they're putting money on their credit charge, and they're intending to tip everyone in their line of sight. So the person who made their drink, and the person who took their order, the person who made their drink, person who took their money. The court said, okay, we're getting in that person's head, and we're thinking that by leaving that tip, they're tipping the whole team that they're looking at. That's responsible for their big, beautiful, overpriced drink getting into their hands. And that may include hourly supervisors, and often does. So there are some nuances to it, but the general rule is hourly employees doing the work are the ones who get the tip, and the employer should have no hand at all, and certainly not take any of that money. In contrast to a service charge, such as a mandatory tip for large parties, like parties of 6 or more, will be a mandatory 18%. That becomes a service charge. The House can share in that. I recommend they not, but I recommend you don't. But it is a different situation. But tips belong to the employees, and now there's a little bit more teeth behind that. Okay.
Okay, so now we're transitioning over to leave benefits. SB 590, commencing July 1st, 2028. Benefits under the state paid family leave program will be available to employees caring for a designated person. When requesting family temporary disability insurance benefits to care for this designated person, the worker must both identify the individual and also attest under penalty of perjury to the nature of the relationship, including whether this designated person is related by blood or what kind of family or familial relationship they have to this person.
Okay, so yet another notice that you have to provide your employees. This is there's a template that the Labor Commissioner is going to develop, and that is expected to be issued February 1 of 2026. That notice will inform employees of their rights to work comp benefits, disability pay, care for work-related injuries, their right to notice of inspection by immigration agencies, their a word about their protection against unfair immigration practices, their right to organize, their rights under the Fourth Amendment of the U.S. Constitution against unreasonable search and seizure, their rights under the Fifth Amendment for due process and their right against self-incrimination. Any legal developments the Labor Commissioner deems material and necessary. And then finally, it's going to include a list of relevant enforcement agencies. So I'm sure it will include the Labor Commissioner, Civil Rights Division, OSHA, and the like. The template that's going to be sent out, that's going to be made available on February 1st, is not per se mandatory. You would be absolutely foolhardy not to use the template from the Labor Commissioner. All you have to have is one Oxford comma out of place, and it could be problematic. Use what the Labor Commissioner publishes. This gets sent to it's given to your new hires. It was given at the time of hiring. And it's just like that 2810.5, the Wage Theft Prevention Act notice that came out, gosh, about 6 or 7 years ago. Now it's part of every new hire package. This SB 294 notice, not just at the time of new hire, at rehire, not just at time of hire, but every year needs to be sent out to your employees. It can be sent by email. It can be hand delivered to them. It can be put in the mail. I believe the requirement, it has to be sent in a way that's in their hands within 2 days. So email it or give it out to employees, and you should be fine. More paper.
Okay, so we have SB 617. This expands the information employers are required to include under the California Worker Adjustment and Retraining Notification Act, known as CalWARN. Employers are now required to state whether they plan to coordinate services for affected employees through the Local Workforce Development Board, LWDB, another entity, or not at all. So regardless of the employer's choice, employers must provide the LWDB's contact information and a description of its services in the notice. This will take effect January 1st, 2026. And importantly, employers should remember that CalWARN imposes broader and more stringent requirements than federal WARN. So while federal WARN applies to employers with 100 or more full-time employees, CalWARN covers establishments with as few as 75 employees, including part-time staff. Another, big difference here is that CalWARN also triggers notice obligations for a wider range of events. So for example, it requires 60 days notice, advance notice for any plant closures, layoffs of 50 or more employees, regardless of the overall workforce percentage, and any relocations of at least 100 miles affecting any number of employees. So in contrast with federal WARN only applies to plant closings or mass layoffs involving 50 or more employees, and in some cases, only if they constitute at least 33% of the overall workforce as a site. So those are, very big distinctions between CalWARN and federal WARN to keep in mind.
Yeah, I touched on this earlier. SB 513, effective first of the year, expands the definition or the scope of personnel files, and to include education and training records in the definition of personnel records. Now, remember, the employee's right to inspect their records. You have to produce their payroll records in 21 days, and personnel records, anything they've signed, anything that you looked at to decide their termination, and other significant employment actions has to be produced to them. And that gets produced in 30 days. You can just make it available for them to review. Our recommendation, I mean, every situation is different. That said, we almost always recommend that you provide a copy to employees, particularly terminated employees, and rather than having them come back into the workplace. The definition of personnel records, though, now includes educational material. So any trainings they did, it's got to state the name of the employee, the name of the trainer, the duration and date of the training, the core competencies in the training, the resulting certification or qualification. You've got to go back, keep this stuff for up to 3 years, and there are penalties and even criminal liability for not properly producing these records. I can't imagine like being in prison and your cellie turns to you and asks, "What are you in for?" And you got to tell them it's because you didn't produce educational records. Try to avoid that. And protections for bias training, SB 303. The legislature wants to encourage us to have training on bias in the workplace. And this does speak to issues of discrimination. And what this does is if somebody in the course of this training reveals a bias, shows some some challenge in that regard, they're protected from that. That will not constitute discrimination, and that won't be a violation of anti-discrimination laws. So it really it removes some of the vulnerability, some of the risks, and I think makes the training for bias in the workplace a more productive environment, and people can speak more openly. I think that's a good thing. Okay, new things on the horizon, not necessarily in place, but all but in place. And Claudia, you want to talk about rounding?
Yes. So courts previously allowed rounding policies if the policy was neutral. So that means essentially it did not systematically favor the employee or employer. So the California Court of Appeal in Camp versus Home Depot USA Inc. held that rounding clock in, and clock out times was unlawful when the employer's system already had or captured the exact minutes worked. And in Home Depot, the court emphasized that employers must be paid for all the time worked, rejecting the idea that these neutral rounding policies are acceptable when we have these digital clocks in this digital era. And what that presents for employers is that if the Supreme Court affirms the pending decision in Camp versus Home Depot, rounding policies will likely be prohibited. Payroll systems must pay employees to the minute, and if employers continue to round, that could expose them to wage and hour lawsuits, and then you'll have to call us. So that's rounding. Peter, I don't know if you wanted to add to that at all.
Yeah, just so we're clear, rounding is, if somebody their scheduled shift start is 8 a.m. If a particular crew starts at 8 a.m. and you have some people that clock in at 7:55 and some people that clock in at 8:05. If you round, then they all should be showing us starting at 8 a.m. Without regard to when they actually clocked in. If, and it has been permissible, defensible maybe is a better word for it, where it was completely even-handed like that. The challenge is that until you really do a deep dive on it, you don't know whether it's been even-handed. Even if the policy is we're going to go back, we're going to round up or round back, no matter what, it may be that you're catching more people who are you have more people who are clocking in at 7:55 who are losing that 5 minutes of work than you do people clocking in at 8:05 who are sort of getting paid an extra 5 minutes. And so if you're looking at a class-wide or a company-wide basis as you would in a class action or pocket case, you're going to run into trouble. And so it's a good idea not to round. As it stands, it's possibly defensible, but as the Home Depot case showed, and I think the Supreme Court is going to hold that it's no longer permissible in California. And there were cases like the Troster versus Starbucks that where the court did not endorse a de minimis exception to time, so that's the direction things are going. I would expect that rounding is going to be a thing of the past for us. Also keep in mind that without regard to rounding, and even rounding and for the start and beginning of a shift time, the meal breaks, the meal periods, your 30-minute uninterrupted meal break never was allowed to round. 29 minutes and 30 seconds is not enough. That's a violation. So that's just a reminder for you that 30 minutes is hard. And then lastly, arbitration agreements have been under fire for years in California. And, we know that claims that include sexual, that are in the nature of sexual harassment or sexual assault cannot be subject to arbitration. PAGA claims in their representative capacity can't be subject to arbitration. There are cases that came down just in the last year or two that where the courts and the legislature has tried to make outright ban arbitration. That's not been successful. And so in California, the energy is continuing against arbitration. There's a decision that came out not long ago, I think earlier this year, that looked at not just the arbitration agreement, but looked at it in the context of, the confidentiality agreement that was signed and other somewhat related agreements. And as a whole, were those did the court looked at whether those were deemed oppressive or unconscionable, rather. Now you get the federal law is much more forgiving and much more welcoming to arbitration. In your arbitration agreements, reference that it is interpreted according to the Federal Arbitration Act. Your business has to be it has to be interstate commerce. But to meet that standard of interstate commerce, it's not automatic. It's not a difficult standard to meet. Make sure your arbitration agreements are truly bilateral. So any claim you bring against your employees has to go to arbitration if you want your employees to be required to go to arbitration themselves. I recommend full discovery rights. Put in the link to the arbitration rules for AAA or for JAMS, whatever service you choose. You got to pay the fees other than what the employee would have to pay to file their lawsuit in Superior Court. Everything else has to be yours, and it has to be on you. And make sure it's clear that they're waiving the right to jury. If you want, I hope that your arbitration agreement is going to be upheld. And that is what we have for you. We do have a few minutes for questions. And I think a slide deck is available. The question is it possible for attendees to get a copy of the slide deck? I believe, Sierra, that is available online, but we can certainly send it around. Our emails are on the title page of the slide deck. And if anybody has any questions that they think of later, we are happy to speak with you. And mostly we appreciate this opportunity to speak to all of you folks. And we appreciate your time. And we wish everyone happy holidays and a healthy and prosperous new year.
Great. Well, thank you again. I actually had a question for you guys, though, since we have a minute. Going back to off the top of my head, I can't remember the SB, whatever, but what about relocation costs? If an employer is relocating someone, can they recover that if, say, the employee leaves within a certain amount of time?
Claudia, I think that was in your, I think that would go by the same standards. Do you have that, Claudia?
I'm sorry, what was it?
Relocation expenses, just as tuition reimbursement, things like that.
Right, like it addresses more directly yeah, tuition reimbursement or a sign-on bonus, but um, I was unclear on is still like how would it be handled if the employer paid for relocation costs?
I see. That is something I can definitely, if you pop your email in the chat, I will happily connect with you on that.
All right. Anyone else have questions?
Hey guys,
Take-
excuse me, I put something in the chat, but you might not have seen it. I was just asking if you have any of the latest and greatest on, I think there are two pieces of legislation proposed or actually passed that were going to affect the employee surveillance laws. Do we know any kind of updates on those?
And there's another one where we can send you an update. I don't have it
Awesome.
on my head. If you want to
Awesome.
pop it in the chat.
Appreciate it. Thank you.
Thank you.
All right, I think that's a wrap. Thanks again to everyone for attending and to our speakers and Jackson Lewis. And see you all again.
Thank you so much.
Thanks.
Thank you.